Annyeonghaseyo, ni hao, kia ora. My name is Tina Huang and I'm a Senior Associate at QueenCityLaw. I recently presented at a construction conference with Brightstar and wanted to reiterate the topic for you here. I will be talking about what lessons we can learn from the past 2 years to try to prevent construction disputes. I have 5 quick points for you. Let's get into it. So number 1, know your contract. I often get pulled into construction disputes from clients, and they can be developers, principals or contractors, and they will tell me they have a huge issue that has blown up on site and they want quick answers. I need to know what form of contract we're dealing with, and extraordinarily people often don't know what form of contract they're dealing with because they're focusing on what's happening on site. Fundamentally, what type of contract you sign, be it a NZS 3910 standard terms or NZIA or in-house contract or even a master builder's contract, is so important. And once we establish the form, we need to know the specific terms and special conditions. What does the contract say? That's your Bible for the project. Also, I have said this previously before, but if you signed with a subcontractor, if you signed as a subcontractor with the head contractor, you are entitled to see the head contract, and you should have reviewed this, but very few do. Secondly, I can't stress this enough. Documentation, documentation, documentation. There is nothing more important than documenting everything. A project can take a couple of years, and during that time, what you agreed with Bob might not have passed down to John or even Joe. So Bob or John or Joe might simply disagree. And now breaking this point up even further, keeping records. I am still hearing of so many gentlemen handshakes on the project and nothing to support that oral agreement. And it is bound to become an issue if you do not document it. Make it a habit of emailing the person afterwards, just a one-liner saying, hey, further to our discussion today, we agreed on X. That will protect you. Plan changes. I do not think I've seen a project go through without amendments to the plans. It is very common for minor changes to be made to plans and drawings, and for this to be done in a hurry to get it to council. But then the contractor builds according to version 5 and instead of version 6, and then you have a fight of whether they even got version 6 in the first place. So prevent that fight, document it. Engineer instructions. Again, a very common dispute is, what was the engineer's instructions? The contractor says the engineer was instructed to do A, while the principal says, no, I asked for B. And then the engineer says, I vaguely recall having this conversation, but we'll need to search my records. But then, of course, they can't find anything. This is far too common, which leads to the next point. Site meetings, minutes and circulated. This sounds so easy, but when you have fortnightly meetings that then turn into weekly meetings, that then turn into a series of daily meetings, and you're concentrating on putting out that problem and putting out that fire and doing your job, people often forget to circulate the minutes or what was agreed in that very important meeting. This again could prevent a dispute later on because people often recollect meetings or conversations differently. So keeping minutes and circulating them to get everyone on the same page is super important. Again, this is a protection and will prevent disputes in the future. So thirdly, looking at fundamentals of a contract. This includes managing delays, retentions, variations, extensions of time, critical paths and liquidated damages. That's a lot to cover, but actually this is Construction 101. 2 years ago, contractors signed fixed lump sum contracts, and now they have no margin and are stuck while costs have escalated and suppliers have been severely delayed. Or has it? While most projects have been severely delayed, we have actually seen some remarkable projects be on time and under budget. I have talked to extremely organised contractors who have pre-ordered Jibboard for the entire year of 2023, so there are no delays. I am seeing more and more contracts now that allow payments for off-site materials, and obviously there needs to be further documentation to ensure it is indeed kept separate. It is so important to keep the communications ongoing with sensible discussions. If a developer tries to hold the contractor to the fixed lump sum contract signed 2 years ago, pre-COVID, that is no longer feasible in today's market. They could contractually argue their position is strong. They will probably realistically find that the contractor is going to cut corners, hit the developer with a number of variations, or just be hung out to dry. So finding workable, reasonable solutions is probably beneficial for everyone. A topic I wrote about recently is that under 3910 Standard Terms Clause 5.11.10, the contractor is entitled to variations for law changes that occur after the tender. This means that contracts signed prior to 11th of April 2022 would be entitled to variations for Matariki Day, which since became a public holiday. A variation for one day may not sound like much, but on a large project with say 100 workers, scaffolding, crane and associated costs, this could be substantial. Retentions is obviously another hot topic. Where is the retention? Is it actually there? When is it due to be released? Is it tied to practical completion or CCC? How is that defined? Is it intermingled with other project retentions and accounts because the CCA actually allows for this? So there needs to be care because there is almost always a fight about retentions. Variations is obviously another topical issue. Has there been clear documentation? Are the contractors entitled to extensions of time? If it doesn't affect the critical path, then no extension of time should be allowed. Liquidated damages are an interesting one because a few years ago, the developers used to put a very nominal figure for liquidated damages and didn't spend much time calculating the actual costs of the holdings and the cost of delay. I have seen head contractors sign contracts with large LDs on their subcontract and have their small subcontractors sign for, say, $50,000 of works with the same high-level LDs of $30,000 a day. And the subcontractor used to just think, well, it's not going to affect me, that's fine. And they used to sign that, but the market has changed. Fourthly, sensible commercial calculations of costs to fix retentions and legal fees. Now, if there has been defective works or an issue on site, but the contractor is refusing to do what you think they should be doing, before you get into a fight, think about the commercial calculations. What is the cost to fix? How much are you actually fighting about here? How much are the retention? What's the potential legal costs? This should give you some clarity on how to solve this issue. The last point is plan for the worst, but hope for the best. This is probably my all-time favorite saying as a lawyer, and especially in construction. Plan for the worst, hope for the best. I say it again because this, of course, will go back to knowing your contract and documenting everything. If you have any questions, please feel free to contact me or my team. Thank you for listening and watching. Thank you.